All right, oui, vous l'avez. The International Criminal Court is now in session. Lord John, the Court Panel International at Uwait. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Madam Court Officer, can you kindly mention the case?
Good morning, Madam President, Your Honours. The situation in the Central African Republic 2, in the case the prosecutor versus Mohamed Said Abdelkani, case reference ICC 0114 0121, and we're in open session.
Thank you very much. Can I ask for representation, starting with the prosecution, please?
Thank you, Madam President, Your Honours. Good morning. For the prosecution this morning, myself, Holo Makwaya, Senior Trial Lawyer, Thomas Bifoli, Marie-Jean Sardachi, Trial Lawyers, Brunhild Lebai, Vanessa Gray, Trial Lawyers, Sanyu Ndagire and Anusha Rawa, also Trial Lawyers. Thank you.
Thank you very much, Counsel. Representation for the victims, please. Ms. Pele.
Merci, Madame la Présidente.
Thank you, Your Honour. The victims are represented by Gilles Dibert-Bekoy, Adeline Bedoucha, Darsven Litzenberg, and myself, Sarah Pele, from the OPCV.
Thank you. Thank you. Thank you very much, Ms. Pele. For the defense, Ms. Nauri.
Thank you, Your Honour, and good morning. I have Dov Jacobs. I also have Shanag Rentré. Behind me, it's Mr. François Jacquemin, Emma Conti, Nolwenn Monique, and Benjamin Duclos, who's with us. I am Jennifer Nari, lead counsel.
Thank you very much, Ms. Nauri. And for the record, I do take note that Mr. Said is in court with us here. A very good morning to you, Mr. Said. I hope I see you well.
Oui, bonjour, madame.
Yes, good morning, madam.
Good morning. Now, welcome everybody to the second day of the closing statement in this case. We will now hear from the defense. Counsel, you have 90 minutes to respond to any specific points raised by the prosecution yesterday, followed by 60 minutes to summarize your case and make final submissions. The registry, as it graciously did yesterday, will be monitoring the time and will inform the chamber when the allotted time is due to end. The floor is yours, Counsel.
Your Honours, members of the bench, we're at the end of our trial. We're taking stock of the situation and we have to now draw the conclusions. The prosecution that has to bear the burden of proof beyond reasonable doubt, since it is the prosecution that has taken the responsibility for bringing this case before the ICC, the International Criminal Court. However, in listening to the prosecution, I've heard no response to the doubts raised by the defense and no answers to the questions asked by the defense since the very inception of the case. Listening to the prosecution, I heard that it was prepared to distort the statements of its witness or simply ignore them in an attempt to impose a fiction that is not borne out by any evidence in the case file. Today, even more so than at the start of the trial, it is clear that the narrative put forward is a distortion of the prosecution's own evidence in an attempt to conceal the flaws in its case. At the start of the trial, the prosecution claimed to have high-quality evidence, especially technical and scientific evidence. What do we see today? No ballistic evidence, no forensic evidence, no autopsy, no medical expertise, not even any medical documents contemporary to the events provided by the witness, which means no evidence of injuries. Now, in a serious legal proceeding, such as before the ICC, photographs of a scar taken 5 years after the alleged event are not indicative of anything at all. It wasn't forbidden to call on doctors. The prosecution has done so in other cases. Here, nothing at all. The prosecution repeatedly stated yesterday that it was not necessary. But one might think that it had evidence to establish an injury or cause of death. It is, after all, their job to prove what they claim, yet there is nothing in the file. Let's take PK9. All the witnesses contradict each other on the cause of the death of the victims, all of them. Now, in such a case, forensic evidence would have made it possible to establish the cause of death, but the prosecution hasn't provided anything at all. Why? His investigator, P3114, told you in the court he is not interested in the cause of the death, and he concedes that there is nothing in the file that would enable us to determine the cause of the death. In reality, the evidence presented by the prosecution is weak and does not support its case. The facts central to the charges are based on a single, uncorroborated witness, which is fatal from an evidentiary standpoint for establishing a legal fact. Witnesses whose identities have not been verified, as admitted by the prosecutor's investigator, that's P3114, or at least one witness who gave false identity, P2573. Facts that are central to the charge rely on witnesses who refuse to testify. Indeed, with regard to two incidents attributed to Mr. Said, incidents D and K, the witnesses refused to appear before the court. So what does the prosecution do when asked if it has abandoned them? The prosecution persists and refuses to face reality. Its own witnesses do not want to support their allegations. And what did it tell you yesterday? Do not worry, there is sufficient evidence in the file. What does the prosecution consider sufficient? Are interviews given to the press. Interviews given to the press in such a case, even talking about a standard of proof would be an understatement. Now, regarding the narrative construction of the prosecution's case, we are also very far from a demonstration or proving a point. During the trial, we discussed the assumptions, assertions, and conclusions announced by the prosecution. And we note that it has been unable to establish any of its allegations. None of the initial announcements were realized during the trial. On the contrary, the prosecution stubbornly ignored any evidence that did not support its case, even though its own witnesses presented a different reality. At the opening of the trial, the prosecution only presupposed the existence of an organization of groups comprising the political coalitions as Selika and Sango without ever revealing this organization. What do we see today? The situation has not evolved. The prosecution still provides no evidence of the organization of these groups. Nothing. Just as it has been since the first day of the case, the prosecution presupposes the existence of a coalition in 2012. And it merely cites three main groups without ever explaining the supposed structure of the coalition. There is not a shred of evidence in the file that allows us to know how the various groups FDPC, CPJP, CPJP Fondamental, UFDR, CPSK, whose leadership is impossible to establish because of the internal and external power struggle between them were organized. There is nothing in the file that speaks of the organization. And yet this is absolutely crucial because all witnesses and experts agree that the so-called Selika coalition is basically a marriage of convenience between disparate groups with no chain of command and no political leadership. So we asked the prosecution, what is the structure of the Selika? To this date, the prosecution has failed to provide an answer. The only way it found, instead of proving anything at all, was to assume that because ultimately groups from the coalition were able to arrive in Bangui on the 24th of March 2013, there must have been a certain degree of coordination amongst these groups prior, and may I insist on the word prior, to 24th of March 2013. And then to presume that such an organization, which has never been proven, would have continued after the 24th of March 2013 without ever proving that either. And we've seen that in the trial yesterday. We heard the PowerPoint comment with a map, which really was not talking about the period in question, and we heard absolutely nothing about what was happening after the 24th of March 2013. What happened to the coalition? And that is the real question in our case. It's about knowing what form would the coalition would have taken after the coup d'etat, if there was one. Now, what would be the structure of the coalition during the period covered by the charges? The prosecution never answers that question. What was its structure, its vertical or organization? What were its members or leaders? What were the instructions, the lines of communications? Were the meetings organized? We know absolutely nothing about the period covered by the charges. It is unable to do so because it is clear from the case file that when the groups arrived in Bangui, the coalition fell apart. And I'm not saying this, it's the prosecution witnesses who say that. From accounts by insiders such as P2105 and P2563, who basically were part of this march, and it is clear that people bearing arms who were uncontrolled were motivated by personal gain, and that other individuals spontaneously and suddenly claimed to be Selika in an attempt to enrich themselves. How can one imagine any coordination, the slightest of coordination, in such a context? Now, faced with this factual obstacle, the prosecution then invents a fiction of Selika government, which allegedly implemented a certain policy. But then, the prosecution should have demonstrated during the trial the existence of this so-called Selika government, and should have called the relevant witnesses who were part of this government. And what do we see today? What do we observe today? Not a single witness has mentioned Jatodia's transitional government, which emerged from the presidential majority known as Selika. None. No, not Jatodia, not Dafan, not Noureddin Adam, not Jubai, not Jono Abba, not Gazambeti, and not Chimangre. None of them. Jubai, Jono Abba were part of the current government, and he spoke about the democratic elections, the deputy prosecutor. How could the prosecution establish the existence of any policy which would have been designed by members of a group of allies from the Selika presidential majority without any witness to speak about this policy? No witness to speak about possible instructions that might have been issued, without any witnesses to speak about any possibly organized meetings. It's just impossible, simply impossible. Furthermore, the prosecution does not establish the reality of the so-called Selika government. On the contrary, if its own witnesses explained that only 9 of the 34 members of the transitional government were from the presidential majority. It's 1/4, a quarter of the government. And the witnesses say, especially P2328, that the KNK remained in place. KNK is President Bozize's party. So we have a government with 1/4 Selika, many staff and ministers from the Bozize party, and some from the civil society. So we're therefore far from a single-party Selika government. In reality, what's clear from the file is that it is a government of national unity. It's a multi-party government, and above all, And this is where the difference lies. It's a government where the members of the government perform their roles independently, contrary to the authoritarian government, which is a figment of the prosecution's imagination. You only need to listen to the three ministers called by the prosecution, who, by the way, are not from the presidential majority, and they all assert their authority and their independence in the context of their office. Whether it's Nicolas Chongai, Prime Minister, who himself refers to my government, and I'm quoting him, the government I led. Nicolas Chongai was never part of the Selika coalition. He claims his role in front of the international representatives, just as P0349 or Jean-Jacques de Mafout, the Minister Councillor for Disarmament, who claims to have played an active role without any influence from Jatodia. So their accounts, the accounts of the three ministers, indicate that the instructions given by the government of Chongai and Jatodia were to implement confidence-building measures under the auspices of the international community. So that these confidence-building measures to stabilize the situation, and a number of meetings were actually organized to these effect. And what are these confidence-building measures? So these measures basically included the establishment of joint patrols, and joint, we'll talk about it. So from representatives of the FOMAC, that the international community called the discipline Selika. That's confidence-building measures. It's the cantonment and debilitating and disarmament of uncrawled armed individuals and the recruitment of new FACA personnel. Why? Because the international community had decided that an 18-month transition period should be put in place. And this is the period covered by the charges. It is a transition period of 18 months, a transition period that's necessary, a transition that's necessary. It is not possible to ignore this reality despite all the efforts of the prosecution. That's doing as if nothing happened in the aftermath of the coup d'etat. The sovereign institutions were functioning as if nothing happened at all. And what's more, this was in a country that was already experiencing great difficulties as a state deprived, as a ghost state, that one that had abdicated its responsibilities. This is not realistic. The prosecution also decided to ignore its witnesses when they explained that during the period of internal unrest, characterized by the presence of uncontrolled armed individuals, civil servants, especially those from FACA, returned to work. I emphasize here that civil servants, including the FACA and not Selika, returned to work. Now, trying to ignore the role of the civil servants, who had absolutely nothing to do with the coalition, the prosecution did not call the chief of staff Dolewaya, the director of police Lingui Sara, or the public prosecutor Alain Tolmo. None of them are members of the coalition, but all these civil servants returned to work. That's surprising, because according to the prosecution's witnesses, all these officials actively perform their duties within the framework of their authority by giving instructions and conducting the procedures in place. For instance, with regard to Lingui Sara, witnesses P2563 P2161, P0349, P1524, P1737, P2478, and P0338 confirm his real, active, and hierarchical role. It should be noted that Linguisara was already the director of police under Bozizé, and he retained his position under Detodia. And still, he holds a position of responsibility in the current Touadéra administration, with so much of witnesses' corroboration on the role of Linguisara. It's really surprising that why he wasn't called to the stand. Benjamin Mallow, director of the OCRB, explained that it was Linguisara, in his capacity as the Director General of the Police, he was the one who coordinated and led all the activities of the various departments of the National Police Forces. And Linguisara directly reported to the Minister of Public Security, Noureddin Adam. Now, in light of the accounts given by the prosecution, if there was a state policy, a policy as the prosecution claims, Linguisara, who is not a Selika member, must have definitely been involved in it, particularly in ensuring the FACA's obedience to the government. And this is what we're being told of. The person who's ensuring FACA's obedience to the government, why do not prosecute him or at least call him to testify? Your Honours, you know, the case file shows that it was absolutely possible for him to be called to testify. The same applies to the role of the public prosecutor, Alain Tolmo. Witnesses explain his active role during the period covered by the charges, particularly at the OCRB. Notably, P0481, P1429, P3056, P3064, P2563, P0547, P2241, P2239, P2105, P0338, P2478, P0787. I'm sorry, but if that's not corroborating evidence, I don't know what is. Moreover, according to a well-informed source, P0234, Alain Tolmo was at the OCRB the entire time. Prosecutor Tolmo is placed at the OCRB by both the working staff there and the detainees, each explaining his role in the arrest, transfer, detention, hearing, or release of detainees. Tolmo continued his career, and he is now the prosecutor of the Special Criminal Court, and the prosecutor of the ICC has publicly praised their cooperation. However, at the same time, in its written submission, the prosecution criticizes Tolmo for having played an active role in certain incidents. But then why not prosecute him, or at least call him to testify? Especially since, once again, it appears from the file that it was entirely possible for him to be called to testify. Now, since the prosecution is depriving the court of key witnesses, it is necessary to draw conclusions from these omissions which create irremediable doubts in the prosecution's case.
Another element that the prosecution proclaimed at the beginning of the trial and is to be found in their brief, the Central Office for the Repression of Banditry, the OCRB, was apparently an opaque location surrounded by very high walls, and it gave the impression of being a hidden prison, a makeshift prison. But that position cannot be held. No prosecution witness has described any such place, not a single one. If we listen to the witnesses, be it staff working at the OCRB, detainees, or their family members, they all say the same thing. The OCRB was a location that the public was well familiar with. It has been in the same place for decades. It's a familiar place. It is accessible to the public, and it was accessible during the period of the charges. What we see from the case record is that the OCRB was operating as usual. The only difference was that the OCRB was understaffed. And so, on a temporary basis, people were brought in to assist with a view to applying confidence-building measures. In actual fact, the mixed patrols were picked by the director of the police, Linguisara, and as I said during the opening remarks, government representatives, including P1019, decided to send volunteers, some of whom had come from former Seleka groups, to make up for this shortfall of staff until a solution could be found, and to stop the people who were bearing weapons out of control and to confine them. This changes nothing when it comes to the roles of the police officers who were there and the way that the OCRB operated. The OCRB operates in the same fashion today. We will go into greater detail, but I would like to stress that the witnesses' accounts show, and I think these accounts have been corroborated, that first of all, detainees were registered at the OCRB, that the prosecutor of the Republic cooperated with OCRB staff. Family visits were allowed. It was possible to file complaints. Civil society observers, such as people from France, the Red Cross, or the FIDH, had access. Even women selling peanuts had access. So this was the apparently secret, hidden location, this description that the prosecution is trying to sell to you. Not a place where little girls came to sell peanuts without fearing anything, entering the compound without any difficulty. A few words about the people held at the OCRB. As we heard from the witnesses, and this destroys the allegations of the prosecution. And if we look at the actual facts, that what actually happened, according to the witnesses, without prior assumptions and without placing our own value system upon these people, then we see the reality, why people were detained at the OCRB. The witnesses themselves said what they had been accused of. They explain various accounts of theft, misappropriation of funds, holding weapons, etc. Furthermore, these people were found guilty. Others were released by a judge. So they were subjected to a judicial procedure. The prosecution also told us that they had demonstrated the existence of an armed conflict during the time of the charges. They are the only ones who hold such a position at the time. Well, no one deems that at the time or that there was an armed conflict between April and August of 2013 in the Central African Republic. The UN Security Council has not taken such a position. The UN expert group, no. The UNHCR, the International Committee of the Red Cross, no commentator, no journalist, no soldier, no NGO. No one has taken such a position. We would have expected that the prosecution would have provided solid evidence to demonstrate the contrary. But what do we see? What do we gather when we actually read the brief? Once again, the prosecution has to ignore their own witnesses. The so-called pro-Bozizé forces, not a single one of their witnesses corroborates such a statement. The witnesses actually said that they did not want politicians to take over this spontaneous grassroots movement that emerged in the second half of 2013. For example, witness P2269 and witness P0405 was very clear about Bozizé. He said this about Bozizé: he's not a good guy. Heavily armed self-defense groups. All the witnesses have described fighting with homemade rifles, bits of wood, even pots and pans. The prosecution has not provided elements to support the existence of any kind of organization between April and August 2013. The few times that the prosecution gives any dates whatsoever, for example, when they talk about sporadic skirmishes, that was after September 2013, so outside of the period of charges. The witnesses have been clear about this point, be it sources from the Central African Republic, French sources, or people representing the international community. I have to insist on this point. It wasn't experts who said this. Not just the experts said this, it was all the witnesses concerned. The ones who were later deemed to be anti-Balaka, the witnesses of the prosecution who were there, and other people who were in a position to know what was going on. The prosecution finds itself at the starting point, at the end of this case, the very same spot where they began. They have no elements demonstrating the existence of an armed conflict between April and August 2013. This is a crucial finding because the knowledge of Mr. Said must be assessed at the time of the alleged events. How can the prosecution allege that Mr. Said would have known about a situation when no one had knowledge of such a thing in 2013? The witnesses of the prosecution did not know, nor did the experts. No one. The confirmed incidents have to be proved by the prosecution beyond reasonable doubt. But what do we see? The prosecution, rather, we see more and more doubts about each and every incident. So many doubts. None of the incidents can be truly established to the judicial standard. The prosecution has provided weak evidence, often non-corroborated, from witnesses who are rather lacking in credibility. We thought it would be useful to illustrate this with a number of examples. For example, Incident E, witness P0622. It initially described in his written statement, in detail, 1 month of detention at the OCRB, 1 month. Yet when he appeared before the court, he said he was only there for a few hours. This truly cast doubt on the plausibility of his account. 1 month versus a few hours. This finding did not keep the prosecution from relying on his testimony as if there was no such contradiction. As for incidents F and N, the prosecution relied on a single witness. We do not know what the date of the incidents were, nor do we know the identity of the alleged victims. These incidents that are so vague, without any corroboration by other evidence, cannot be accepted before the International Criminal Court. This is where we come to the issue. A witness who does not give information that can be cross-checked, a witness who contradicts himself on key points, who lies about his own identity. Can one rely on a single witness like him? This is the reason for the principle of testis unis, testis nullis. When we have witnesses contradict themselves, who lie about their very own identity, this just won't do. But this is what the prosecution is asking you to do, to believe a single witness who makes no sense. A holistic approach is not possible with witnesses who are unreliable and not credible. Mr. Said must be afforded the benefit of the doubt. It is remarkable to see that despite the contradictions, the accounts regarding the incidents that witnesses have given us do give the lie to the prosecution's statements. One example. In the vast majority of incidents, there was testimony and documents showing that there was a legitimate reason for arrest, which runs counter to the prosecution's allegation that people were arrested just because they were perceived as being Bozizé supporters. The prosecution was blind. Today they claim that P2519 was arrested because he was perceived as a Bozizé supporter, whereas P2519 himself explained that he was found guilty of association with Seleka members, Incident L. Furthermore, this person, according to the prosecution, he was arrested for being a Bozizé supporter. I'm speaking about Incident L. Furthermore, in the case of 10 incidents, Mr. Said was not even mentioned, and for the remaining 8 incidents, he played an extremely limited role, one of overseeing or keeping an eye on the activities. The prosecution has never demonstrated anything illicit within the context of an operational police station. Facing this situation, the prosecution has decided to do the best they can and use anything at hand. They're ready to do anything to mislead the chamber. This is very serious. they turn. It's not mean that they're doing their best. They're doing whatever they can't want with the little that they have. For example, P2692 allegedly was threatened by Mr. Said. And yesterday, the prosecution told us that P2692 was allegedly threatened by Mr. Said. Allow me to reiterate, P2692 never said who he was threatened by. He never said that. And yesterday, the prosecution said that P2692 was apparently threatened by Mr. Said. Madam President, Your Honors, when P2692 was shown 3 times, when he was shown photographs of Mr. Said 3 times, including a selfie of Mr. Said, and I don't think there's anything clearer than a selfie, P2692 did not recognize him. He does not know who Mr. Said is. He saw a photograph, photographs 3 times. Yet, the prosecution says, oh, yes, he was threatened by Mr. Said. Such false affirmations are very serious. One cannot take, this is daydreaming, wishful thinking. We are in front of a court here. Such a thing is unacceptable. A person's life is at stake. Finally, one word about the lack of demonstration of Mr. Said's responsibility. First of all, allow me to speak to the fact that there was no hierarchy, no clear hierarchy within the OCRB during the transition period. According to what the witnesses have told us, it was impossible to determine who was at the OCRB at any particular time, and generally speaking, it was a chaotic situation. Chaos reigned within chaos. One witness told us that it was impossible to determine who was the leader of the OCRB because it was constantly changing. And this was witness P0234 who said this. According to the accounts of various witnesses, all kinds of people were apparently in charge of the OCRB. For example, some people said it was Mazengue or Noiro, Linguisara, Tahir, Modestri, General Abu, a Sudanese colonel, a man who had a long beard that went all the way down to his chest and long hair. Someone from Chad called Ibrahim or Mahmoud, Jamin Jago, and the list goes on. In order to skirt this problem, the prosecution decided they'd rather presuppose that Mr. Said played a certain role, just as the prosecution presupposed that Mr. Said was a senior leader within the Seleka coalition without ever demonstrating such a thing with actual evidence. These presuppositions do not stand up to analysis because there is literally no evidence on the case record. No witness said Mr. Said belonged to one of the coalition groups, not a single one. No witness saw Mr. Said in Sibut or during the time that people were heading towards Bangui. No one knew him. No witness knew him before he got to the OCRB, and that is a logical thing because He was in Bangui for several months before the various groups arrived. And in actual fact, at one point, he was a driver for Abdoulaye Hissène. The presence of Abdoulaye Hissène in Bangui was confirmed by P1019. Above all, it is clear from the case record that a source who was in the know, P1019, according to this source, this witness, Jitoja didn't even know who Mr. Said was. He did not know who Mr. Said was. We put that point to witness P3114. So according to the prosecution, a senior Seleka leader was unknown to Jitoja. This just won't fly. This is not on. And as if nothing were wrong, the prosecution, desperate, relied on an interview that Mr. Said allegedly gave to an anonymous person representing the FIDH. In what case before the ICC? A court that keeps to the highest standards. How could one imagine that anyone would ask a bench to rely on an interview to an anonymous person subject to no particular code of ethics, and the main person involved didn't even know this person? It's up to the prosecution to investigate. The prosecution did not call the person who actually conducted the interview. The prosecution did not investigate this interview and did they try to cross-check words attributed to Mr. Said by this anonymous person? Otherwise, if one were to rely on this, this would be a The prosecution was not able either to demonstrate any policy was being implemented by way of any common plan at the OCRB. Why? Because, as we've already said, the witnesses from the prosecution themselves have said that the people who were being held at the OCRB were prisoners, common law prisoners, and people who had been bearing arms, who had gone out of control, who claimed to be Seleka members. Was that a common plan of the government established, particularly at the OCRB, to arrest Seleka members and criminals? Is the OCRB being charged with operating like a normal police station in this case? If that's the case, then the entire police hierarchy, Seleka or non-Seleka, the official police hierarchy that is still here, that is still present today, the whole hierarchy should be here before this court, as well as the prosecutors of the Republic who were carrying out their duties in 2013 and who are still in place today. At the end of the trial, we have demonstrated that there's nothing left in the prosecution's case, nothing left. Madam President, Your Honours, throughout the course of the trial, gradually, you had an opportunity to listen to another version of what happened, and the reality has emerged. But since that reality does not suit the prosecution, They have decided to merely dismiss it. Yesterday, the prosecution said, and I quote, I will quote what was said yesterday, "This case is not a case against the Seleka coalition, nor is it a case against the government led by the Seleka coalition. It is not a case against the Seleka coalition or against the government led by the Seleka coalition." I'm not saying that. The prosecution said that. And the prosecution thinks that they do not have to demonstrate the slightest contextual element. No need to demonstrate the existence of the Seleka or the structure of the Seleka that allegedly took part in an armed conflict. Not necessary. No need to demonstrate the existence of a single-party government that apparently decided upon a particular policy. But no need to demonstrate who decided upon a plan. But I ask you, what are we doing here today? What are we doing here today? Here we are before the International Criminal Court, which deals with international offenses. Since the prosecution has conceded that they do not need to prove the existence of contextual elements, which are indeed the elements needed to distinguish a national offense, a domestic offense, from an international offense, they have actually conceded that they do not have the authority to put Mr. Said on trial. They do not have the authority to file suit against him because they have not presented a case that deals with international crimes. The finding cannot be escaped or avoided. The prosecution has not demonstrated international crimes. The prosecution have not demonstrated charges beyond reasonable doubt, and Mr. Said can only be acquitted at the end of this trial. Madam President, Your Honors, to finish this response, it is Mr. François Jacquemin who will continue, followed by Mr. Jacobs, and I will ultimately make the final remarks. I thank you.
Thank you very much, Ms. Naoui. Mr. Jacquemin, François Jacquemin, would listen to you now.
Merci, Madame la Présidente.
Thank you, Your Honour. The prosecution says that there is a policy of discrimination by relying on insufficient supported evidence and without showing the existence of a policy upstream. The absence of crucial evidence prevents us to confirm the existence or the unfolding of incidents. The prosecution relies on witnesses and documents that are not very credible. Its method of presenting evidence is a piling up of witnesses who contradict each other. But the prosecution puts them forward as if they are a cohesive whole. They use the term Seleka in a very generic way, without ever asking or showing who is the person that might be concerned. What is the precise role? What sort of group do they belong to, etc., etc. The prosecution has consistently repeated, Seleka has said this, Once a Seleka did that, without ever identifying or explaining who that person precisely was. For example, men, and I quote, wearing civilian attire who should have robbed P18108 are described as Seleka without any justification, without evidence. Another example of the lack of proof. In April 2013, as regards the explosion at Cité Jean 23, prosecution does not provide any tangible evidence on who caused that detonation, under what conditions. The prosecution simply asserts and speculates. But above all, in addition to this probative weakness, the prosecution states, without any examples and mistakenly, the existence of a discriminatory policy which took place at that time. Regarding the 7th arrondissement, the prosecution states, without evidence, that it was perceived as pro-Bozizé. Yet, President Jotutilla comes from that area, if you are to believe the various witnesses, and the mother of Adam is in the same tribe as some chiefs of that neighborhood. Particularly in 2013, when you look P281 and 2, the 7th arrondissement is a mixed neighborhood with several mosques and many Muslims. Part of the inhabitants cheered the arrival of Seleka when they entered Bangui. The 30th of March 2013, you can see car 2023-30 and car OTP 20-20320-632. In the streets of Bangui, persons were filing down and had a banner, and I quote, "The 7th arrondissement of Bangui supports the changes that occurred on the 24th of March. The prosecution has simply dreamt up a discriminatory policy. In reality, the government attempted to guarantee a state continuity and to re-establish public order in Bangui. They tried to fight against criminality and tried to introduce a disarmament policy. Disarmament of former Seleka elements and disarmament also of citizens who were not authorized to carry weapons. Thus, P1289 states that the Seleka were looking out for weapons in the 7th arrondissement. It even goes so far as to say that there was an establishment of a committee for disarmament. In this case, the leader of the 7th arrondissement suggested jointly, and I quote, that we leave the chiefs and the youths of the neighborhood look for hidden arms in the sector so that they can hand them over to the authorities in exchange of an end to the endless searching in houses. Also, the same is true for Boirab. P0834 states that in the spring 2013, and I quote, "This neighborhood had a lot of arms, and the Selike was concerned about that situation." And then they go on to confirm. 2180 confirms. P0100 confirms. According to 0119, the leaders were required to look for those arms. It's not the soldiers that were looking for them, but the weapons that some were hiding. As regards the disarmament operation in Boirab of August 2013, it came about as a response to the shots on the National Assembly the day before the investiture of President Duterte. It was an essential. So, prosecution suggests that thefts which took place particularly in Boirab, particularly the disarmament operations, but it forgets to inform you that Boirab was the wealthiest neighborhood in Bangui at that time. Witnesses show that the areas targeted were regarded as the most riches. If you listen to P7204, according to P0547, they looked at the most wealthy houses. P1825 describes, and I quote, "The Selike only came into the houses that were well built, saving those who seemed to belong to the poorer inhabitants." P0119 and P0547 confirms this selection of fenced-in, gated houses. Uncontrolled elements targeted the more beautiful houses. And as regards Ngaisona, he was one of the wealthiest men in the area of Bangui. This is not a discriminatory policy, but acts of elements that were under control, who wanted to profit from the situation to enrich themselves. In truth, there were two different agendas which were running alongside each other in Boirab. That of the government, which legitimately wanted everyone to disarm, on the one hand, and on the other hand, the uncontrolled elements, on the other hand, who targeted rich individuals against the government's wishes. So how did the government react to this? Partly politically and partly materially. President Duterte condemned the looting, invited the mayors and leaders of the neighborhood of a meeting at the presidential palace, where he listened to their complaints and then asked the mayor of Bangui, and I quote P1524, some money, some pocket money, as compensation to victims. Furthermore, the government reacted with the police and judicially. For example, thanks to mixed patrols of officials and support backup elements, the uncontrolled elements, which the prosecution generally calls Seleka, just to keep the confusion going, went to Pungulu with the assistance of FOMAC. That's true also for the 7th arrondissement. Finally, following a judicial action was rigorously put into place, and those who carried out looting were prosecuted and convicted. Tolmo, the prosecutor, required 10 years of imprisonment for 25 people who were convicted. 17 were convicted to 8 years in prison. This clearly shows that no state policy supports these outrages. On the contrary,
Thank you very much, Mr. Francois Jacquemart. Mr. Jacobs, your turn.
Madame la Présidente, Mesdames, Messieurs les juges, bonjour.
Madam President, Your Honours, I am going to look at another aspect. I'm going to start with this following question. The prosecution returned to this issue yesterday and has not proved anything yet. Already for the Seleka, they have never come up with a proper definition. The prosecution presupposes that there's a force and never proves this. All the witnesses, this prepared by who were so-called anti-Palaka, no one, not one of them, said that I am pro-Bozizé. No one said I am trying to get Bozizé into power. They said we don't want that this policy is continued. Some didn't talk about it at all. But no one said, I'm pro-Bozizé. At this stage, it is a denial which the prosecution is doing. They're not taking an isolated approach. They cannot assert.
Juste, je résume.
Let me sum up so that it is correctly interpreted. No prosecution witness said I'm pro-Bozizé. It is impossible to understand the basis for the prosecution that these are pro-Bozizé forces. No witness. It's not possible to present a case like this. And if you read the submissions of the prosecution, there's not even an allegation. It's not even a question of evidence. At no point did they say Bozizé himself did something. You won't find it in their submissions. So we have a phantom Bozizé force, and nowhere in the submissions prosecution tries to say Bozizé did this himself or Bozizé did that. It's not even an absence of evidence. There's no statement or assertion. We don't know who these pro-Bozizé forces are. They are just presumed without being shown to exist. Another difficult point which the prosecution didn't correct yesterday is that we didn't know the period covered by Bozizé, April to August 2013. Prosecution doesn't date anything at all, never. And when it dates something, It is after September 2013. Worse, many of the examples are of the 5th of December 2013. That's to say, 4 months after the period in question. So what doesn't matter if they're anti-Balaka, and that hasn't been shown, will be organized on the 5th of December. The period that we are interested in ends in August 2013, so it has no relevance to this case. So finally, they're not having any dates to anything. The prosecution hasn't shown anything. Another example that was shown by the prosecution yesterday is the funding of the Bozizé forces, the pro-Bozizé. The prosecution allegates that they relied on a single sources when you talk about a single approach to the proof, to say that an entire movement, which was an armed country, and the entire country was funded. We have one sole witness for that, who talk about the Mokum witness and some bank transfers. That is all. To talk about the funding of an entire group. Where's proof of these bank transfers? I don't know. If they are bank transfers, there must be some backup for that. I haven't seen any file supporting this. And as regards the Mokum house, it's not serious. An entire movement, an entire armed group was funded by a mortgage of one house. This is not a serious allegation. Particularly, we don't understand the position of the prosecution in their current case. When in the Mokum case, the prosecution said, we do not feel or think that Mokum funded, and they even dropped the case against him. Today, it is a major organizer of the anti-Balaka. So the question isn't even who believes these witnesses. Today, what does the prosecution itself believe? The Mokum case or the Said case? Prosecution doesn't even believe its own witnesses. It didn't say this yesterday in the hearing because it is aware of the absurdity of this statement, but in the submissions it talks about heavy weapons. Heavy weapons. All the witnesses talk about bows and arrows, of pots and pans. Where do you see these heavy weapons? We don't see any mention in the filings. It's true as regards the intensity of the conflicts, the fights. The prosecution said that there were big fights in the hinterland. Madam President, Your Honours, as a symbol of the lack of connectivity between what the witnesses say and what the prosecution is arguing, we have P2251, which describes the famous attack of Bosongoa in September 2013. The self-defense group were beating pans and made a lot of noise and shouted, "Leave, leave, we are here." And then, at the beginning of the attack, the Selika elements who were guarding the village were taken by surprise. They fled to their base and left their weapons behind. And their chiefs were concerned. This is the intense conflict which the prosecution says happened. Another example of deforming the reality. The prosecution said yesterday that the government was aware that there were pro-Bozizé forces that were getting themselves organized. But once again, it is the price of deformation of what was going on, deformation of evidence, deforming the evidence. There's a striking example of this. The prosecution said yesterday, and I quote, it is in the transcript of yesterday, the members were sent to Zongo as a mission by the minister at that time, Adam, during the period of May to August 2013. The aim was to gather intelligence of the pro-Bozizé forces. Here I'm referring to the ordre de mission cited in paragraph 38 in the submissions of the prosecution. This is what the prosecution told us yesterday. This position is unbelievable. If you look at these ordres de mission, which perhaps you've already done, Your Honours, Madam President, they do not say a single thing about the pro-Bozizé forces. Perhaps the prosecution has further evidence on this issue, but it cannot say a document says something when it clearly does not. This document talks about a mission to Zongo, full stop. You don't find the words pro-Bozizé. You don't find the word monitoring or gathering information. This is not an acceptable procedure in front of the ICC. To end about this armed conflict, Your Honours, prosecution, once again, denying the reality, denies the fact of armed conflict once again between March and August 2013, which is the relevant period for us. Yesterday, the prosecution said it refused to listen to a single witness who was a specialist in humanitarian international law, which is P15, that was called upon by the defense, who has worked in the United Nations and also worked in the ICRC, who worked for the Swiss Foreign Affairs. This witness is not credible, was not reliable. So it means that no one is reliable or credible. United Nations, the IRCR, the Security Council. Did we hear the prosecution talk about it yesterday? No. Not a single international organization with people on the field, NGOs, no one. I must stress this point. No one said at that time that there was an armed conflict between April and August 2013. Afterwards, that's another story, but it's not relevant to our case.
Just so you're guided, Mr. Jacobs, you have 10 minutes more to respond to the prosecution's brief. 10 minutes for now.
Pardon, vous voulez que je continue 5 minutes après 11h, c'est ça? Juste pour comprendre.
Continue at 11:05?
Yes, please.
Merci, Madame la Présidente.
Thank you, Madam President.
Depuis le début du procès,
From the very beginning of the hearing, the prosecution has just simply ignored this fact. The irony is, and we explain this in our submissions, the prosecution who wants to completely ignore the ICRCR, and this has already been explained to you, Kay has already said that. He said it's careful, but he wants to protect the civilians. It's important. It is important for the ICRC. So if there's an armed conflict they can prevent, they will do so. That's what they say. And it is only in March 2014, that they said there was an armed conflict. Prosecution in their submissions quotes the customary law in the ICRC. They like to use them from a legal point of view, but when they want to say how it is applied and how the ICRC sees it, they do not heed what they are saying. This denial, once again, has not been addressed. It's completely ignored by the prosecution. From the unanimous amount of source, they make no mention, and they say the ICRC is wrong, the United Nations is wrong because of this. They don't say anything, nothing, not a single word. They are, but ignoring the reality doesn't mean it disappears. I'm now moving on to my next point, Madam President, Your Honours, namely the absence of any proof on the incidents that occurred. The problem of evidence are the same here as elsewhere. If you read the development as regards the incidents in the submissions of the prosecution, we have the impression that we have a resume of all the witnesses rather than true evidence. We have statements as regards the chain, sometimes contradictory confirmations. Often, these are not corroborated. We gave examples in our submissions, but sometimes you can have an incident in the same paragraph. You have a witness who says a person was stopped and arrested by such an individual, and in the following sentence, another witness, it's another person. So there's a contradiction from one sentence to the other without any further explanation. So which witness are we to believe? Prosecution spent a lot of time yesterday, a lot of time to explain to us that it is not serious, that the evidence is not corroborated. It's not serious that it lacks a certain coherence. It's not serious that some of the evidence is contradictory. It's not serious if there's a problem of dates. It's not serious if we don't know the identity of the victims. What wishes? Rather than looking at the solid basis for their evidence, the prosecution defends the weaknesses of their arguments in their final submissions.
Je répète.
I repeat, this is a weakness on the part of the prosecution. The prosecution tried to save the situation of incident J, but that doesn't change the situation. P2607 and 5 don't agree on anything. Not on the date of the incident, nor how the arrest took place of the brother 2607, nor on the detention of his brother, nor the respective presence in the OCRB, nor the role that Mr. Said was supposed to have played within the OCRB. One said he was inside, the other said he was outside, so he was in two different places at the same time.
ni sur la manière
nor the way in which the death was announced to the family. Nothing. Prosecution showed brilliantly a lack of corroborative evidence, nothing more or less than that.
P2607.
P2607, the key witness of the prosecution in this incident, was not present when his brother was arrested. He's not the witness when the brother arrived in the OCRB. He's not the witness with the alleged detention of his brother. He was not a reliable witness when his brother left the OCRB. He's not the witness when the death occurred. He's a witness of nothing. The prosecution told us yesterday that P2607 recognized his brother at the OCRB. How? Because he saw part of the leg in a pickup with a blue sweatsuit, sweatpants. And here again, the witness said, I think it was blue. This is not a serious form of identification for the ICC. So the brother of the 2607, that is the entire person in Bangui that wears blue sweatpants. Prosecution seems to overlook, regardless of the dates, but we have a military document in the file which was given by 2607 that is a prosecution witness that has brought it. This military document says that the witness, the brother, died several months later in November from a disease, a sickness. But that's something perhaps we shouldn't take into account. But this document creates a doubt to the benefit of Mr. Said.
L'accusation a dit hier.
Prosecution said yesterday, and I've also given you examples, that this is an isolated incident, whereas the prosecution should have a holistic approach.
Les deux mémoires.
The two submissions show clearly that the contrary is true. Prosecution frequently relies on one witness who's saying one thing and then makes it a generalization. If you read, the defense submissions are holistic in their approach, because frequently there are dozens of witnesses who corroborate an issue. That's a holistic approach, Madam President, Your Honours. But to have one reference at a footnote to show a very important thing, for example, the funding of the anti-Balaka, is an isolated, single-handed approach. I see the time, Madam President.
Well, indeed. We're going to break off for now for some 30 minutes. And when you come back, you still do have your 60 minutes to summarize your case on behalf of Mrs. Said. So I rise the court for 30 minutes.
All rise, we will be.